Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti, and today we have another great panel. It is Big Tech, Too Big to Break Up. The panel is presented by the Legislation Committee today, and we have two experts with us this morning who are going to help give some context to the panel. Greg Goulib is counsel at Deckard LLP, and he is also the co-chair of the Media and Technology Committee here at the ABA Antitrust Section. Hi, Greg.
Hi, John. Great to be here.
We also have Alexander Lifshitz. Alexander is special counsel at the Fried Frank law firm, and he is also a vice chair with the Legislation Committee at the ABA Antitrust Section. Hi, Alexander.
John, thanks for the invite.
Great. Greg, let's start with you. What are we doing today?
Sure. As we all know, big tech companies, and most notably Amazon, Apple, Facebook, and Google, are being scrutinized by antitrust enforcers and policymakers around the world. One of the potential remedies being discussed is breaking up one or more of those companies, either for having violated the antitrust laws or to pursue other non-antitrust goals, such as reducing the perceived political power of those companies. This panel explores both the rationales for breaking up big tech and the challenges involved in pursuing such a remedy.
Alexander, let's turn to you. Why is this all important and relevant?
This is important because, as Greg mentioned, big tech is really under the antitrust microscope right now. The FTC is reviewing the last 10 years of non-reportable transactions of Google, Amazon, Apple, Facebook, and Microsoft using their 6B powers. The FTC also created a special task force to monitor competition in the tech sector. Similarly, DOJ is investigating some of these big tech companies for stifling competition and looking into how they're leveraging their networks to do so. The European Commission is investigating Google and Facebook about their data gathering practices, and this is after they already levered billions of fines against Google. Congress has had multiple hearings involving large tech companies, and in fact, Senator Elizabeth Warren has called for breaking up big tech, including by designating tech platforms as utilities and possibly splitting out their related businesses and unwinding consummate mergers. Putting all this together, with all this going on, we want to understand whether first there are legal tools to break up big tech companies, and second, if we do have tools, whether it's prudent to use those tools to actually break up these large companies if antitrust violations are discovered. And if they do so, what would be the repercussions on the markets of breaking up?
Greg, what do you think we're going to get out of today's panel?
So we want to know what enforcers and policymakers should take into account as they consider breaking up the big tech companies. We want to hear about recent legislative and regulatory proposals involving big tech. And we want to find out about the case law that is out there on breaking up companies for antitrust violations and any lessons we may draw from those cases. Finally, we would like to get both the U.S. and the European perspective on all of these issues.
Great. Greg, Alexander, will you stick around? Let's watch this program together, and then come back at the end, and maybe we can talk about some of the takeaways. Will you guys stick around?
Yeah, sounds good.
Of course.
All right, great. Well, with that, let's turn it over to the panel's moderator, Anant Raut. Anant, take it away.
Thanks, John. My name is Anant Raut. I'm co-chair of the ABA section of Antitrust Law's Legislation Committee. On behalf of my co-chair, Scott Perlman, welcome to Virtual Spring Meeting 2020. Topic of our panel is Big Tech, Too Big to Break Up. And joining me today are the Honorable William Kubasik, former chairman of the Federal Trade Commission, professor of law at George Washington University, and non-executive director with the United Kingdom's Competition and Markets Authority. Also joining us is Nicholas Banisevic, Head of Unit at DG Comp, responsible for antitrust cases in the field of information technology, the internet, and consumer electronics. And rounding out our panel is the Honorable Maureen Oldhausen, former acting chair of the Federal Trade Commission and current chair of the Global Antitrust and Competition Practice at Baker Botts. My comments today are my own and not the views of any present or past employers, but let's jump right into it with our panelists. So the topic, the question is big tech too big to break up? And is that the right question that we should be asking? Would our panelists like to respond?
Well, I'll kick it off. I think one of the questions here is, why are we jumping to the end of the story, right? Is there a problem where a breakup is the right remedy? And that's one of the issues that I think needs careful analysis. Is a breakup going to make the market conditions better off? And is it in a remedy for some anti-competitive conduct, rather than just saying there are big companies and we no longer like big companies, so we're going to make them pull apart in one way or another. So I think it's worthy to discuss the topic, but I think we need to be a little careful about making sure that the appropriate predicates are in place.
I think that if you find an infringement or you find a serious competition problem, the short answer to the question is yes, you can. It's feasible. There's a large amount of experience in the 130 plus years of U.S. antitrust law that gives confidence that there are tools available. There are tools developed in the field of corporate law involving restructurings and reorganizations. There's an enormous amount of expertise that suggests that you can develop and imply structural remedies. You can apply patent licensing remedies. You can apply hybrids that involve conduct and structure. I think the missing element is that we have not done a great job of systematically studying that experience and assimilating it, making it readily accessible. There's a great tendency in our field to focus first and foremost on questions of liability and treat remedy as a bit of an afterthought. That's changed some in the past 20 years, especially for experience with merger enforcement. But I think the most important need is to focus on study that vast body of experience we have, because I'm confident that once we answer the basic question that Maureen has posed, if you decide what's the solution, if you think you have a problem, the answer is we have a massive experience that suggests that structural conduct remedies and hybrids indeed are feasible and could be applied to big tech.
Thank you very much. Thanks for the invitation as well. It's a great pleasure to be on the panel with such a great panel. I have to give the usual disclaimer that these comments are my own and not necessarily those of the European Commission. In answering the general question, I think I want to echo a lot of what Maureen and indeed Bill did say, which is I think you first have to ask on the merits and sequentially before deciding what the appropriate tool for intervention is, you first have to decide if indeed there is a problem. And then if there is a problem, you need to think about whether it's a case-specific antitrust problem or whether it's potentially a more systemic issue that goes beyond antitrust. And that might have then implications for what kind of tool is appropriate to deal with the problem. And in that regard, and I'll develop some of these thoughts as we go on through the panel, of course, competition law is a discipline based on individual case-by-case analysis with analysis of effects. And the purpose and scope of any remedy, and I think there's a scope for discussion along the lines of what Bill was saying in terms of what the remedy can or should be for an individual case. But the purpose and scope of any individual remedy is, of course, designed to address the case-specific issue or harm that's been identified. But if it's considered there's a kind of broader, more systemic harm or problem beyond an individual competition case, then indeed one can think of policy or regulatory solutions that are on top of that, complementary, and they're more likely to be appropriate. And it's not for competition law to deal with everything through one case. So I think I'll leave it there for the introduction.
And we're going to be getting more into the actual potential harms in this particular space, but I'd like to focus at the outset a little bit more on the remedy aspect of it. And Nick, I'm going to start by directing this question to you in a moment. The question being, aren't structural remedies more desirable than conduct remedies? And the background for this is that I think there's been a shift in thinking that structural remedies are just a one-time disruption. Conduct remedies often require ongoing supervision by enforcement agencies, which puts them in the position of becoming de facto regulators. Effective conduct remedies are limited to the lifetime of decrees. In the absence of actual regulatory authority, enforcers are limited to litigating the meaning of sort of settlements for ongoing violations. If we're looking at remedies in general, should we always be focusing first on structural rather than conduct?
Well, I think first I would confine the discussion to our discipline. We're competition enforcers or competition practitioners. So within the competition framework, where you're analysing the remedy to an individually identified harm in one specific case, I think, again, it depends on what the harm is that you've identified, and you need to find the remedy that's appropriate to that harm. Our legal structure and our legal system, I think I will read from some of our legislation. I mean, it does allow the Commission to bring an identified competition infringement to an end, that we can impose any behavioural or structural remedy which is proportionate to the infringement committed and necessary to bring the infringement effectively to an end. And then it says, this is our Regulation 1, structural remedies can only be imposed either where there's no equally effective behavioural remedy or where any equally effective behavioural remedy would be more burdensome for the company concerned than a structural remedy. The reason that I read through that legal test, which is not something I often do on panels, is, I mean, to illustrate, there are two principles at play here, core principles. There is a power and a duty on us to, when we've identified a harm, to have an effective remedy, and effectiveness is very important. But there's also a duty of proportionality. So whilst there is a reference, as you heard, to the possibility of a structural remedy to be imposed, there's also the clear requirement of proportionality, so that you can't just impose a structural remedy when there are more proportionate behavioural remedies that can be imposed. Now, so I think it's a bit difficult, bearing those principles in mind, to give a general answer about whether structural remedies are more appropriate than behavioural remedies. Structural remedies are, of course, more far-reaching than behavioural remedies. But over the years of our experience, and I can talk about some of those cases, in conduct cases, in antitrust, as we call it here in Europe, we have found that behavioural remedies can and have been effective. Of course, some have been better than others, and we've learned from that experience. And it's not necessarily the case, I would say, that the fact that there's the need for ongoing monitoring, that's a bad thing, because you can have flexibility to adjust to differing circumstances. So I think it's worth bearing all those things in mind. It's also worth just maybe wrapping up this point that, I mean, whilst we have that power, as I say, to impose structural remedies, in conduct cases, I mean, since we've had that power, which is now more than 15 years old, we haven't imposed any structural remedies in adversarial antitrust proceedings. We have had what you might call structural remedies where there have been legally binding commitments offered in electricity, for example, in terms of separation of transmission and distribution, and in one cooperation case, but we haven't yet seen cause in an individually identified case to impose structural remedies. And again, I think that comes back to this balance between, of course, on the one hand, the need to have an effective remedy, but also the need to be proportionate.
Let me see if the other panel comments with their thoughts.
So one important, I think, fundamental factor to think about is, are we talking about mergers, right, where we're saying we're going to have a structural remedy that maintains the competition as it was before the merger was happening, right? So we already knew what the market looked like. We already knew how these things functioned. And what we're trying to do is to allow a merger to occur where the pro-competitive or competitively neutral combination can go forward, and we're going to preserve competition through a structural remedy in of a part of the market where the merger might reduce competition. So we're kind of preserving the status quo there. Now, when you take that idea into a behavioral, not a merger situation, then undoing the company or making it spin off things, I think is going into an area where we don't have that much knowledge necessarily about how the market will be operating. So I think, for example, about the McWane case that the FTC brought, which was a conduct case, a Section 2 case, and the remedy there was to say, stop doing the kind of full-line forcing exclusionary conduct that you were doing. And, there was never any consideration of, well, you need to spin off, that, section of your business. So I think we have to think very carefully about what we're talking about when there's a presumption towards structural, because I think it is primarily in the merger situation.
I should add that I have a disclaimer as well. I don't speak for the Competition and Markets Authority in the UK. If we were using the analogy to, say, medical science, a physician who's prescribing a course of treatment has in mind a variety of alternatives for the patient based on experience. What's worked, what hasn't. I think what all physicians know is that every course of treatment has what are called side effects. Identifying what those are is important. All of the remedies in the competition arena have side effects. None of them are completely clean. Divestitures can require ongoing monitoring and supervision. A patent licensing mandate can require continuing follow-up that deals with whether the full package of IP has been transferred along with relevant know-how. Conduct solutions have varied effects. So the starting point is to ask, based on experience, what has worked in the past. But I think in approaching given solutions, I think it's important to recognize that our previous work in the merger and non-merger area has shown that the boundaries across these different types of remedies, structure versus conduct, shows that there are a lot of hybrids and there are a lot of instances in which the boundaries are blurred. So the starting point, again, I think, is to think what's the competitive ailment and how to fix it. And as Nick was saying before, sometimes that problem may reside in other public policies. It may be a function of other forms of government intervention or private behavior that are not directly or easily reached by competition law, which may call for a more flexible approach. It's one reason I'm increasingly fond of the United Kingdom's market investigation regime, which allows the CMA to look in a somewhat broader sense at what the competitive problem is and to formulate solutions without having to anchor each step of the analysis in traditional competition law principles.
And Bill, let me just follow up with you on that. You talked about alternative or a variety of remedies and hybrid solutions. And I guess the overall question I'm going to ask you is whether structural versus conduct is something of a false choice. And being the legislation committee, one example that I have in mind is that Senator Warren and others have introduced legislation that would, in effect, be like a Glass-Steagall for tech companies and prevent companies from competing in their own marketplaces. Do you think structural versus conduct is maybe a kind of a false dichotomy when looking at remedies in this space?
I think it is, and part of what you're suggesting, Anant, is that we look at other examples. From the 1930s, we had a series of striking examples that involved a mix of structural and conduct features. One was Glass-Steagall. Another that had important non-discrimination elements was the Public Utility Holding Company Act, which mandated broad-based divestitures in the energy sector. Another was the McKellar-Black Airmail Act, which forced the separation of commercial airlines and companies that made commercial aircraft. There were a lot of solutions that involved legislative intervention that went beyond conventional antitrust principles. And another possibility I'll add, when I was a young person at the FTC 40 years ago, one of the projects that we focused on a great deal is whether you could use rulemaking to mandate the separation of ownership and control of petroleum products pipelines to create basically a stronger and more robust common carrier approach to dealing with those facilities. So I'm thinking about the competition policy problem or the broader obstacles to competition. I think a close examination of these other models and experiences is enormously valuable.
And a little later on, I'm going to ask Nick for his experience and perspective from Europe, where I think that they are considering some more of these hybrid models than maybe we are in the US. But I want to next turn to Maureen, who I think has some very relevant experience here. Just staying on the question, the focus of our session about breaking up companies. And the question being, how would enforcers think about the fault lines to use for breaking up massive companies? And by way of background, Maureen was acting chair of the FTC when they released the merger remedies retrospective. And I think two of the interesting highlights of it were that of the 89 merger orders studied, all remedies involving divestitures of ongoing businesses succeeded, but buyers of selected assets, meaning less than an ongoing business, didn't always succeed at maintaining competition. So, Maureen, from an enforcer's perspective, if you're contemplating a structural remedy, a breakup, what factors do you take into account? How do you envision what that remedy would look like?
Well, I think you're drawing on that. Certainly, if you have gone all the way down the road and you've determined that there is an antitrust violation and that you've determined that the breakup is the best choice to preserve, because again, the issue here is competition and benefits for consumers, right? Because I think that's maybe gotten a little lost in what this is all about. So this is going to be the thing that will make it better for consumers and preserve competition that perhaps had been lost through some kind of behavior. I think that type of study shows that having a good understanding of how competition works in the market and what support systems need to go around the asset to allow it to continue to function effectively, and also to understand what consumers want, right? Because we've seen some remedies to create new kinds of products that consumers have just rejected in the marketplace, right? Because you think about some of the Microsoft decisions. Again, that wasn't a breakup, but again, what will you end up with a state of affairs that is actually better for competition and better for consumers? Because you don't want you certainly don't want the cure to be worse than the disease. So I do think that looking at what we know from effective merger remedies can be helpful to determine what could be an effective divestiture breakup. But one thing that I would also mention in that regard is Bill is mentioning history, but when you look at the breakups that were done under the antitrust laws, in areas where there were strong other things like network effects, we've seen those broken up entities essentially be reassembled, right? Because there are those benefits. So you need to understand those. I don't think you can just say, draw the line here and, you do this and you do that without understanding the market dynamics that created that in the first place. So again, experience is the best guide, I think.
And Bill or Nick, any thoughts on what enforcers should take into account if they're at the point where they're considering breakup as a remedy?
I mean, one thing that we've alluded to is the important question of viability. If you're going to mandate a separation of assets, are you establishing a new entity that's going to be able to succeed, either standing on its own or perhaps under the ownership of another enterprise? The insights of that come, as Maureen was suggesting, through past study of previous experience. And one thing that the European Commission and the Federal Trade Commission have done in a very healthy way since the late 1990s is to spend resources asking what worked and what didn't. How many assets do you have to put together? What's the critical mass? What capabilities? What human talent has to be assembled in order for the new enterprise to be effective. So one thing that I think the enforcement agencies have done, this is certainly true in Brussels and Washington, is to take very careful note from case to case of what specific techniques worked. And viability is a crucial concern. And I think you find that the agencies that do the largest volume of merger review today have a very good checklist that identifies what you need to establish a viable enterprise. So this conscious effort to build into the entire life cycle of competition policy an examination, a look back, even a quick look back at your remedial experience is an extremely important guide. I just finish on that point by saying a humbling element of this is that all of this, and a lot of merger control, a lot of Section 2 remedial choice is experimental. You don't know precisely in each context what's going to work and what isn't. And there's no shame in making choices that turn out not to be fully effective. The only shame comes in not looking back and asking, why didn't it work? Or, just as important, why did it work? Sometimes for reasons that you didn't anticipate. So we're all involved in an experimental evolutionary process. And a key element of experimentation is this habit and custom of going back and asking what worked and what didn't. And certainly in the merger review area, DG Comp, the FTC, to pick two, have devoted a lot of effort to asking that question. How did it all turn out?
And Nick, I want to turn to you, but I want to ask a follow-up question on this same topic. Maureen alluded to the fact that there have been some industries that have network effects, and those have complicating factors when you consider a breakup in there. In sort of the digital space specifically, I think one of the issues that has been raised is how large and sort of interwoven and complicated platforms are, and trying to understand, which pieces feed into which. So I will point out on the one hand that there have been successful divestiture remedies as parts of mergers where even when the acquiring company didn't have the underlying infrastructure, like an AB InBev, Grupo Modelo, or Springleaf OneMain, the agencies came up with kind of a multi-year leasing of the infrastructure to the acquirer so that they could get up and running with the asset. At the same time, you've had divestitures that have resulted, like in the supermarket space, of just the divested entity just closing down. Do the agencies have the capability and the know-how to look at sort of these complex interwoven markets with network effects and figure out how to make a divestiture work? Nick, let me start with you.
I won't say no to that question, but I'll go beyond the facile answer. I think it first is important to remember the context, as Maureen said, between mergers and conduct is different. Of course, in a merger analysis, you're looking at prospective combination of two companies, and the structural solution that, if you have a divestment, is one that would be applied before they've merged. Whereas in the context of behavioral conduct, the hypothetical question is splitting up something that already exists. So I think that is an important caveat, and therefore there's an inherent logic, if you like, in the merger context of having clear-cut structural divestment type remedies. And indeed, that's our general preference as a matter of policy in mergers. Now, I mean, for the second part of the question, to the extent that you could draw lessons from mergers for antitrust, if you were ever to get to the stage of considering a structural remedy. And again, let me stress, I'm saying this in the hypothetical. I mean, Commissioner Vestager has said that structural remedy should be considered as a last resort, but I think you'd need to look at the kinds of issues that both Bill and Maureen alluded to in terms of viability, how the business would look going forward, the impact on the market and on consumers in a number of regards. And I'm not sure that network effects as such are a complicating factor, or one that we wouldn't be able to broach, but it's something that you would need to factor in based on the specifics of the market concern. But as I say, it's somewhat hypothetical. I think the same question applies, and maybe we'll talk about that a bit later, about just how we analyse these issues substantively for a conduct case, but I'll leave it there for the time being.
Anant, I just interject on Nick's point to say that in many respects, these kinds of judgments put a premium on an agency's building the expertise to understand the sector it's looking at. It's the result of the accumulated knowledge and understanding. And I think there again, agencies today spend a lot more attention than they did, say, 20 or 30 years ago in trying to accumulate and retain knowledge about specific sectors and phenomena so that they make better judgments about what they have to do in specific instances. So it's a knowledge retention, knowledge accumulation question. But I think agencies do a better job of that. And I think one thing to focus their attention on the issue that you posed, and that Nick was addressing, is from the moment you open up a file, to ask the question, what do we want? What do we think at the moment is the best solution? What do we think the problem is? What do we want to do about that? Now, you learn a lot about that during the course of an investigation or a proceeding, but I think having that question in mind on day one is very helpful. It helps focus your attention on what the destination for competition policy should be in a specific instance.
Maureen, did you want to add anything to that?
No, I mean, I do think as kind of circling back to my point about experience and understanding the market, and, it's something we say all the time in every case. It's, every market is different. Every, merger is a different case. People sometimes try to say, well, you let, a merger go through where there was a lot of private label competition in the market, and you said, well, that was sufficient. But then in a merger in a totally different product line, you said, oh, the private label wasn't counted. That was the situation I had when I was the chair. And so I think that just shows, like, in each one it's different. The thing I would be worried about, and while I agree with Bill that you do want to have an understanding of what might be the answer if there is a competitive problem, how you would address it, I would be concerned about saying, we want a case, we want to break up. This is something, so we're going to force fit a theory into a breakup just because there is this clamor to say, oh, big companies should be made smaller, right? And antitrust is the tool to do that. So while I completely agree, you don't want to kind of go all the way through, a whole case and litigate and then say, oh, well, how do you fix this, right? But on the other hand, just be careful about sort of this drive towards saying, aha, breakup is a tool that we should be using more, so let's just apply it kind of willy-nilly.
And you've each talked about kind of the ability to the need to understand the market and the specifics of each market that you're looking at, which brings me to the next big question for this group, which is whether the tools of competition law are adequate for digital markets, digital platform markets. And let me take a minute to make the argument. When people are talking about big tech, they're usually talking about four companies in particular: Amazon, Apple, Facebook, Google, but they're not always talking about the same issues. And in the range of cases, investigations, complaints that we've seen worldwide with these companies, it can range from, it includes some stuff like predatory pricing, self-preferencing in their own marketplace, attempted monopolization, tying your own products to your own hardware, using your data that you've acquired in one market to then move into a new market. These are all pretty standard antitrust theories. And my question for the group is antitrust, just as it exists today, does it have all the tools it needs, or does it need to consider new theories? Are there things unique to digital markets that would require thinking in ways that we haven't thought before?
Can I have a first crack at this? I think it's a good question. It's an increasingly popular question as well. Again, when we take a case, we don't try for the sake of it to fit conduct into certain existing categories. But having said that, as you were alluding to, essentially, and I think a lot of the conducts that we've seen in recent years, in our cases in Europe at least, are familiar. They're tying, their contractual restrictions, exclusivity, and again, the fact that they are applied in markets that haven't been necessarily considered before is neither here nor there. We hadn't considered nails and nail guns when we did a tying case on that in the 1970s. So I think there's nothing new there. I think the question has also several dimensions, and the first is are the analytical tools able to deal with these issues of network effects, two-sided markets, free products, importance of data, those kinds of things, which some people say, oh, these are new phenomena, and so you need new or different tools to analyze them analytically in individual cases. Broadly speaking, I don't think that's the case, that we need new tools. These are not necessarily new phenomena. Two-sided markets, network effects have been around in the economic literature in markets for decades. So they're not new as such. Perhaps the intensity of some is more important, the nature of the network effects, the scale and the importance of data, perhaps that's more intense and therefore needs to be analyzed appropriately. But I don't think that in that first dimension of analytical framework, that there are radically different tools that we need. I think antitrust has shown that it's flexible to adapt. The second element of it, however, is, I think, and again, without being complacent on any of this, I think we do need to ask ourselves questions where you have network markets, tipping markets, where the harm can materialize in such a way that there's no way back once the harm has reached a certain point. There are legitimate questions that we need to ask about the timeliness of our intervention, the effectiveness, and here we do come back to the effective nature of the remedies. So I think, as I say, we've got good experiences over the years in different cases with remedies. We've seen some that have worked better than others. I think that's one of the main challenges within antitrust, is to make sure that we have effective remedies tailored to the harm in the individual case. And again, that's something that our commissioner is very determined to take forward as we move on. And she's raised the question of whether, beyond the normal mere cease and desist provision in a remedy, in other words, stop doing what you've been doing, whether you might need more restorative or kind of prescriptive remedies to address the harm or to restore competitive conditions that would have been there absent the abusive conduct. I think there's a legitimate question about whether we need more interim cases. By that I mean where you impose an interim remedy while the main investigation is going on. And as you know, we've had our first such decision for some 17, 18 years last year in the Broadcom case. So I think, again, we need to not be complacent, stay with the times, but we need to also distinguish between the analytical framework and where the tools are, broadly speaking, in my view, are fit for purpose, but also this complementary dimension of effectiveness and making sure that we can address the harms that have taken place.
Yeah, I'd add that I think for the conceptual framework, the analytical framework, as is the case in Nick's experience, there's a great deal of flexibility in the U.S. regime. I'd refer to the D.C. Circuit's decision in the Microsoft case, where the court emphasized the malleability, the elasticity of Section 2 of the Sherman Act, that there is not a fixed set of categories that constitute improper behavior, that it's an elastic concept subject to rigorous analytical standards, but it's adaptable. And I think that opinion underscored a key point about at least the conceptual framework in the U.S., which is that we should be less concerned in looking at specific categories of conduct. We should focus more on concepts. concepts dealing with what we think the theory of harm is. So that should be the big starting point. That is, why do we think this market is not working well for consumers? What's failed? And not to necessarily approach it with a set conception about what the specific analytical pigeonhole the behavior should be fit into, but starting with that question. And I think the DC Circuit's decision is an instruction to use that concept-based approach. Certainly in the US, you have other elements of adaptability. I mean, the famous Section 5 of the Federal Trade Commission Act, which deals with unfair methods of competition, is a deliberate effort to create a mechanism, I would say not successfully applied in lots of instances, but a deliberate effort to create a degree of freedom for the administrative body in the United States to engage in an adaptive process of making adjustments where an existing framework might appear to be too rigid or limited. And I think, again, another example of a competition system seeking to have a concept-based approach plus a different institutional technique for addressing it, again, is the markets regime in the United Kingdom, where the focus of the inquiry is, has there been an adverse effect on competition? That's a broad mandate to ask. Now, you have to prove the adverse effect on competition. You have to have a theory of what that is. But then you have a policy-making intervention tool that gives you a great deal of flexibility to pick a solution, which could be including a divestiture, but could be conduct-related controls. So I see a lot of effort by agencies to use a concept-based approach rather than a category-based approach. There's an important degree of elasticity in many systems to do that, and interesting possibilities in some systems to use a different approach, which is why I think comparative study in this area is so valuable. That is, you've had a lot of experimentation in different jurisdictions as a way of stepping back and saying, how have these different tools worked? And are they worthy of adoption by other jurisdictions?
Maureen?
Yeah, so I mean, I also am a big fan of the DC Circuit's decision in the Microsoft case. I think it did really very carefully parse out these issues and with an important focus on what antitrust is supposed to be about and on consumer welfare. And I think those continue to need to be the lodestars for antitrust enforcement in the US. So you're asking if antitrust has, the right tools. And I also think we can't be complacent if there are anti-competitive things happening in the market. We need to continue to sharpen our tools to be able to identify them. I would never say, we know everything and we're done. Economics obviously has been a really good tool for us to continue to figure out where an anti-competitive effect is happening or is likely to happen. But with that being said, I do think the laundry list of complaints about the tech, companies has to be very carefully sifted to see what actually is something that is a competitive issue that we would be worried about, that actually makes consumers worse off, because and that antitrust is the right tool to use. So issues about data uses that we don't like, I think privacy law might be a more appropriate tool to use for that, rather than trying to force fit that into antitrust in a way that creates some very strange cross currents of saying something we would normally think is an efficiency that's expanding the market and creating new products is somehow a bad thing, right? Because it's using consumer data, and so that antitrust is going to stop that versus some other regulatory tool. I also think some things that are very common in markets have. In lots of markets, I would be concerned about prohibiting in an antitrust, through antitrust, because the impacts on other markets. So you talk about, the ability of a company who sells products in the marketplace of products of others to also offer its own products. So I'm going to hold up my can of, store brand seltzer water and say, as a consumer, I think I'm better off that I can buy this. And so I would be concerned about using antitrust, which applies broadly across markets, to say, somehow this isn't allowed because there's a big platform company that, we don't like who's doing this, without that careful analysis of, is it really making consumers worse off? So I think those are some of the important issues to say, like, do we have the tools? I think generally we do. I think Bill and Nick have noted that. Can there be problems in these markets? Of course, there can be problems in every market. We can't just say, oh, close our eyes, there could never be a problem. But what are the problems and what are the right tools? Is it a competitive problem? Then antitrust is the tool. If it's some other issue, I don't think the antitrust regulator should be stepping in to do it, because I think it's a question of expertise. I think it's something that, other, values can certainly be considered through regulation and other, other mechanisms. So I think I'll stop there, just to say we need to think very carefully about what consumers, the benefit is for consumers versus some other interests are, and that's what antitrust is supposed to be focused on.
And Anant, I just mentioned that an interesting case to study on this is the experience in the United Kingdom where, as a result of what's been called the Furman Report, the UK government has made a commitment to making adjustments in the institutional framework to create a digital office, a digital unit, whose ultimate location hasn't been identified yet, but it might be the telecommunications regulator, it might be the Competition and Markets Authority, but to create a new mechanism for developing prescriptive rules, ex-ante rules, and to bolster the capacity to do ex post enforcement. So there are, again, interesting policy-making adjustments and experiments underway, and each jurisdiction that's thinking about coming up with its own approach, I think can usefully study all these examples in deciding what to do. But we certainly have some jurisdictions, and I single out the UK, that's going to take a try at making an adjustment to the framework to increase flexibility in the conceptual analysis, but also in the implementation mechanism.
And this adjustment to the framework that you were talking about, I think, is an interesting one. Look, there's a lot of, if you ask the antitrust bar and the antitrust community, is antitrust capable of handling these types of markets? I think there's general agreement, yes. But I want to push back against that a little bit with some of the criticisms from about antitrust laws that exist today, because there are arguments that there are things unique to these types of markets, to these types of companies in the digital space, that we need to consider some sort of adjustment to the framework. So some of these ideas are like when you have these massive companies that can cross-subsidize one part of their business with another profitable part of their business in a way that allows this other part of the business to run, below cost. Do we need to reconsider kind of our bundling standard? Predatory pricing. We have a framework for predatory pricing, but I think the normal antitrust economics just assumes that companies have to, in some medium term, make their money back. And you have companies that for a decade can, just run losses because of outside funding. There's a question of whether we need to find a way to sort of quantify attention markets or personal data markets. And Senator Klobuchar, for example, has introduced a bill on exclusionary conduct because that would shift burdens in certain cases, because it's been so hard to bring those types of cases in these markets. So, does it need to be treated? Are digital companies so large or so interconnected or able to operate at a loss or below cost in a way that traditional antitrust economics and enforcement just hasn't previously had to contemplate? Do we need to make some adjustments?
I think if I can jump in again, there are a number of interrelated issues there. It's again whether you're talking about something case specific, and so your examples there about predation or mixed bundling are, I think, they're legitimate questions to ask in the antitrust context. Again, I can only speak for the EU in a sense, but we've had a predation case last year. We don't have legally a recruitment legal standard in the EU for predation. But I think, again, we've shown that we're able to adapt to individual conducts and cases. For the slightly broader questions, I mean, as maybe an aside, the attention market issue, I find that interesting. It almost seems to me like it's something that companies who have an interest in not being found to have market power or dominant, they say, well, look, it's an attention market because everything competes with everything, in the sense that I can choose to spend my time watching a film, downloading music, watching TV, reading an ebook. And then you would say, oh, all that's in one attention market, but I don't think those products are all in one market. So I think we have to be careful there. On the burden of proof issue, that's interesting as well. I mean, it's been raised in various reports. I think the issue here for antitrust is not so much a burden of proof issue, in the sense that it's always our burden of proof to bring a case and to show that there's been harm. But it's rather the standard of proof, by which I mean, what do we need to show harmful anti-competitive effects in an individual case? And I think we all have that standard, or generally across jurisdictions, and it may vary, but at least speaking for the EU and the US, generally you need to show harmful anti-competitive effects. But I think the question or the challenge is to make sure that we're, if you like, not really exaggerating that standard. So I'm not talking about doing cases per se. We still need to show effects, but to ask the question, how do we do that in a reasonable, administrable, practical, and timely way, at the same time as ensuring that the company can defend itself, of course, without necessarily seeking academic perfection. And I don't think I'm the only one to kind of raise that question. At least you've got judges in the UK from the European courts asking that kind of question, which, as I say, is not to go to a world or go back to a world where abuses are per se, but to make sure that the standard is a reasonable and administrable one.
So let me just weigh in particular on the issue of data and the importance of data and data markets. I think there's a lot of sort of smoke around this issue. So this is where one of the benefits of also having been at an agency that does consumer protection is important, because when you go back to the FTC's 2014 Data Brokers Report, which is all about how widely available so many types of this consumer data is from so many different sources. We looked at 9 data brokers, all the things that they had available, and all the market segments that if you go on the website of any of these companies and you want to kind of slice and dice down to a market of I went on recently, it was like St. Patrick's Day lovers and people who Easter bunnies, and then dog lover. I mean, there's quite a lot freely available out there, and so I think one of the hard questions we need to ask is, for antitrust purposes, are we actually concerned with a company who uses a resource that's it's not foreclosing it from others, but just uses it better and competes better through it, and is able to serve consumers' interests or serve ads better, or just sort of design product better because of this? Just sort of doing it better. And that's one of my concerns. Again, privacy is an important value. There are laws, and they continue to evolve, about restricting uses of data. And I think that's, certainly very appropriate. But for antitrust purposes, I get a little worried when people just sort of hand wave and say, oh, a data market, and so there must be an antitrust problem because some companies have, really use this kind of data a lot more effectively than others. Because I think it gets very hard then to say, well, what is competition on the merits, right? If doing better than the other guy is now suspect, I think the system starts to move away from its traditional roots. So there can be specialized data. There's been lots of cases brought on that, from insurance data to mapping data to, all different kinds. But for consumer data, so much of it is widely available. So I think we just need to be really careful about, blurring the boundaries too much there.
One critique, which Anant referred to, takes the form of a extremely skeptical view about the quality of enforcement, certainly in the United States, but maybe more broadly. Maureen had a prop with her can of seltzer water. I can't quite move the camera to show, but I have a bookshelf in back of me with a very large collection of books published in the last 3 years that have a scathing denunciation of the U.S. regime in particular. And in part, it deals with a view of which goals should motivate competition law enforcement. That critique says that, in part, the conversation we're having is too cramped and limited, that the focus of attention should be not simply on microeconomic technicalities, but on the fact of market power by itself and how to deal with large market power. And a number of recommendations for reform. One category is do more with what you have. But there's another category that says, for the US again, burn it all down and build it up, and build it with a new set of controls on corporate size as an end in itself. So certainly one possible motivation in the system, in the debate, would be to take that path. And I would have thought that if Senator Warren or Senator Sanders had become the president of the United States, we would have seen a real effort to change the goals framework. And to do that, I suspect that might not happen now, that we might be more in the category of doing more with what you have, and maybe adapt the conceptual framework itself and alter the goals in part. And I just acknowledge that critique. It's a powerful one. In the US, it's growing dramatically. The debate would be that some of these concerns that we have with specific technical microeconomic policy effects are beside the point. And that is an increasingly important element of the debate. Doug Melamed has a forthcoming paper in the Antitrust Law Journal where Doug says, do we have a problem in that those of us who've been in the antitrust system for a long time are not able to have an effective conversation with this new critique, which is much more emphatic in saying that you only answer these questions by rethinking the underlying question of goals. I'm not attributing this to a EU perspective, United Kingdom, but it's certainly a debate that's taking place about the US system itself.
Yeah, and from the perspective of our committee, we're seeing a lot of that because we also focus on policy, where you have a lot of folks who are outside of the traditional antitrust sphere weighing in. Some of it is, less informed than others. The others are bringing a fresh perspective, a labor perspective, it is a policy debate that has been going on for several years, and I think is going to continue, kind of regardless of the outcomes of the election this year. I want to turn now to sort of our next big question, which is what can we learn from prior cases, both in the US and the EU? And I want to start with, 4 seminal cases in the US. And for the benefit of viewers, I'm just going to try to give a thumbnail of these cases. The first being Standard Oil. This was a case that the DOJ filed in 1909 because Rockefeller owned so much of the vertical distribution of oil in the U.S. They could basically set the price for it. It was a 6-year case. It ended up with the company being broken up into 34 separate companies. The long-term result was those 34 companies ended up coordinating, and they ended up down the road recombining into, among other things, ExxonMobil, ConocoPhillips, and Chevron. Then you had AT&T, which was an 8-year case, started in the 70s. At the time, AT&T was the sole provider of telephone service throughout most of the U.S. And provided long distance for 100%. It was alleged to have illegally manipulated its dominant position in equipment. And the remedy was that AT&T agreed to give up its local operating companies in exchange to holding onto Western Electric and long distance, which resulted in a thriving third-party market for the sale of phones and lower prices for long distance calling. The long-term result was competition on the most profitable parts of telecommunications, but also recombination of some of those companies that had been broken up back into what is now AT&T. There was IBM, which was a 13-year case, spanned 3 decades actually, where the company was alleged to have maintained its dominant position in general purpose digital computers, in which IBM took 70% of annual revenue. It was dropped by Assistant Attorney General Baxter after he found the evidence of the monopolization to be flimsy. But in terms of the long-term result, Tim Wu has argued that having, quote unquote, a policeman at the elbow the entire time resulted in IBM being more cautious and opening the door to companies like Apple to emerge in the 80s. And then there's the Microsoft case in the 90s, where Microsoft was alleged to be illegally protecting its operating system monopoly and illegally seeking a browser monopoly. It's a multi-year case. As Maureen has alluded to, in June 2000, Judge Jackson actually ruled that the company should be split into 2 parts. The appeals ended up decided with a shift of administration, and the Bush administration came in indicating that it really just wanted to focus more on price-fixing cases, and so that the company ended up not being broken up. But the long-term result was that it arguably opened the door for Google and other companies like that, and basically Internet 1.0. And this might be primarily for Bill and Maureen, but Nick, you should feel free to jump in before we get to the EU cases. Which of these cases do you think are most applicable to what we're seeing in the debate about big tech today?
I think they all have a lot to teach. In some ways, they all raise questions that are fascinating and hard to answer. I mean, one basic question is whether, for example, the mere fact of running a case has a remedial effect. That is, put aside the question of the formal remedy that comes at the end of the process. Is the simple fact of having the case important? Tim Wu's policeman at the elbow. It's a fascinating hypothesis. It's hard to test in practice. If you were really going to test the effect of the lawsuit itself, you'd have to have access to the records of entrants who came in and expanded. That is, in the case of IBM, you'd want to talk to other companies and say, how did the fact of the government's case that ran for 13 years affect your behavior? In the case of Microsoft, how did the fact of the Department of Justice running the case affect your willingness to enter and expand? We know without a doubt, in the case of IBM and Microsoft, that the running of the major monopolization cases, in IBM's case, not the DOJ alone, but over 40 private cases, in Microsoft's case, not just DOJ alone, but the European Commission and private rights cases in the US, they unmistakably had a major distracting effect on the company. 2 effects. One is that you had to devote a lot of resources to defending the litigation, including resources of your business people. And the company records, and in conversations with people who were at the companies at the time, there's no question that it had a chastening effect too. That is, more and more decisions got run through the legal department that the business people used to take on their own. Thomas Watson Jr.'s autobiography about IBM talks about how much more cautious, in a sense, IBM became in the 70s. Conversations with acquaintances who were at Microsoft during the key time say that no doubt the law department became more important. So we know that there is a distraction effect, there's a chastening effect. How much did that actually increase entry and expansion? It's really hard to measure. It's a fascinating hypothesis. It's worth studying more. But one possibility is simply the fact that you have the case running creates openings and gives other people more breathing space. What's a bit elusive, I think, is trying to prove that in a rigorous way. I think that AT&T and Standard Oil both show that there's a lot of resilience in the system. The the prediction on the part of the defendants in both of those cases was economic catastrophe. Standard Oil said you're going to ruin the economy, you're going to destroy employment, you're going to deny the U.S. the ability to mobilize if it has to engage in what becomes the Great War, and you're simply going to wipe out shareholder value. None of those things happened. The system was a lot more resilient, and the outcome, I think this is another telling element, is at the time Standard Oil was decided, the assessment of the case and the remedy at the time was terrible. This had no effect, but not all of the firms, Standard Oil was not able to recombine entirely. You had 5 major survivors: Standard Oil of California, Standard of Indiana, Standard Oil of New Jersey, Mobil, and the Atlantic company, the Atlantic Richfield company. You had 5 where there'd been 1, and you had the opportunity for entry and expansion by companies that become known as Gulf, Texaco, and Shell. So I think we know over time that was a stunningly successful remedy. Imagine what would have happened if DOJ had lost that case in 1911. Our system would have looked much different. So part of what's humbling about it is that in many instances, you don't know what the actual effect of the case is going to be until maybe decades later. And if you're an enforcement authority and you're being asked today, well, what did you do? Do you know it's going to work? And where are the results right now? The answer might be, I don't know with absolute confidence it's going to work. And it might be 10 or 20 years from now before we really know. But I think it's worth running the case right now, simply because perhaps the chastening and inhibition effect is present. So I think they're great cases to study. It shows that the economic system is very resilient when it comes to breakups, extremely resilient and adaptive. It also shows that in many respects, if you're asked as an enforcement official, is this going to work? And when is it going to work? The answer might be, I'm not sure. And I'm not sure when.
Maureen?
Yeah, so I mean, Bill has gone through the cases kind of exhaustively, so I won't. I can't top that. But one thing I would say is, even enforcers live in a world of opportunity costs, and I think that has been very much underappreciated in this debate about have the agencies done their jobs and things like that. I think there's a valid debate to be had about whether they should have more resources. When people say, "Oh, you should have brought this case or that case," it also means those resources are being devoted towards those things and not towards other things. So when I think about at the FTC, the focus that has been on healthcare and more entry and allowing more competition in healthcare markets and pharmaceutical markets, and the difficulty of bringing the activist case all the way up to the Supreme Court and winning that. And when people say, "Oh, you were just focusing on the easy cases," well, are the easy cases the ones where there's more direct consumer harm happening today in the market that we need to address? So I think, theoretically, it's kind of easy to say, "Oh yeah, you should, pursue like very aggressive theories," but that also has to be with the understanding of what then aren't you doing? And so when I was the chair, we had a historic number of cases in active litigation, and that was very expensive. It costs a lot of money for expert fees and staff time, and I just think it's necessary to weigh those carefully, because if you're doing one thing, it means maybe you're not doing something else that might be of equal or greater importance to consumers. And today, we're all here remotely because of a health crisis, right? And so I think, the focus that antitrust has had on healthcare and that the FTC has had on healthcare has been a very important one. And I'm a little sorry to see it get somewhat undervalued in this great focus on tech companies.
If I can add two in this tour of U.S. cases, just on Microsoft, two observations that I think are very much worth studying. One of them goes back to Nick's point about proportionality. The DC Circuit did not uphold the district court on all of its theories of liability, and it remanded for further consideration. And there's a fairly significant passage in the DC Circuit's decision that says, on remand, we remind the district court that the basis on which we have found liability is narrower than the basis on which the district court found liability. And there's a fairly strong statement in the decision that says, we're not telling you what remedy to pick, but as you choose the remedy, there's got to be a good fit between the remedy and the theory of infringement and the scope of the finding of infringement. So this notion in the US jurisprudence really echoes Nick's point about proportionality as a key consideration in the litigation of Section 2 cases. The other point is that I think by failing to understand and learn from past experience, Judge Jackson, who tried the case in Microsoft, and the Department of Justice in the States made a serious blunder. Judge Jackson spent one morning holding a hearing on remedy. The parties had asked, Microsoft had asked for 2 weeks, DOJ said maybe a week, but Judge Jackson, after having an initial hearing on the remedy that morning, said, I'm done. Nobody stood up from the plaintiff's side who said, can we approach the bench and say, you're making a big mistake, because no reviewing court is going to have confidence in a big structural remedy if you do not have a more deliberate and elaborate decision on remedy. DOJ and the state sat at the table instead of saying, you're making a huge mistake. This is reversible error. And indeed, the DC Circuit said it was reversible error. But Judge Jackson seemed to have no awareness that this failure to have a more elaborate process was going to be fatal. It was going to bring the case back. I think the case is another lot of important lessons there about how you run cases. And at least for litigated Section 2 cases, Nick's point, proportionality is going to matter to the U.S. courts too.
Nick, let me bring you into this from the EU perspective. And certainly there have been some key cases in the digital space. More recently, there was the case against Microsoft that involved tying of Windows players to Windows, Internet Explorer to Windows, with orders that were issued to provide a consumer choice screen and an order to untie Windows Media Player from Windows, as well as an order to supply interoperability to rival group server operating systems. And there have also been 3 cases against Google that have resulted in multi-billion euro fines for abuse of dominance. What lessons do you think we should draw from that? Are there key ways that you think that the European approach has differed from the US approach?
Yeah, that's an interesting question again. I think I'll talk about the individual cases in a minute, but in terms of your overall question about are there differences in approach, again, I think there are 2 dimensions, the complementary dimensions of antitrust enforcement, and beyond that, on top of that, potential legislative or regulatory solutions. And again, I think my own view is for both, and primarily because that's our domain for antitrust enforcement. My own view is that the differences between the EU and the US are overstated. I know that's not the only view out there, but I think people latch onto, or some people like to latch onto, 1 or 2 cases where there may be a difference in outcome, but they miss the bigger picture where we share the same goals of consumer welfare. There's a legitimate debate to be had about what that means, which comes back to my standard of proof topic about what that means. But we share that same goal. We share the same approach of analysing effects in the markets concerned based on the conduct. And so I think the difference is overstated. Of course, there are differences sometimes in some high-profile cases, and as I say, I think that gets amplified sometimes. I always like to mention that sometimes the US goes further than the EU in some cases. And so that doesn't get mentioned so much. I mean, the examples I've got are Intel and Qualcomm, although I also know that there are differences within the US on the Qualcomm case. So I think a bit of perspective is important there. In terms of the complementary regulatory agenda which goes beyond antitrust enforcement and which is increasingly important. Again, I think, Bill, you're all obviously closer to the US debate than I am, and I'm sure Bill is right that the fact that Senators Warren and Sanders are now essentially no longer candidates will shift the debate somewhat. But my own view is I still don't get the sense that the parameters of the debate are different, in the sense that there are two complementary questions, which is, one, how do we make antitrust enforcement case by case as effective as possible, which is what we've been discussing. And two, beyond that, are there systemic issues, whether they relate to data, privacy, which are systemic or structural, relating to contestability, but beyond the realm of individual case by case antitrust enforcement? And do we need to have solutions in that regard? The substance, of course, is critical, but I don't think that the parameters of the debate are, at least at that high level, are so different. And as you alluded to earlier, and indeed that's our approach, this complementarity between individual antitrust enforcement and regulatory consideration. And that's something that the Commission is looking at and moving forward in these days, weeks and months. Just to finish very briefly on the individual cases, I think you learn, I mean, it's been a theme, I think, of this panel on a number of the topics. You of course learn from individual experience, and you can see a thread actually from Microsoft through to Google in that regard for the cases that you mentioned. So we had in the Windows Media Player case this untying remedy, where the order was, well, you've been tying, and now the remedy is you must untie, but you can offer an untied version of Windows Media Player as well as offering the tied version of Windows with Media Player. And there wasn't a provision that the price had to be different. And people said, well, why is that? Whoever would take the version without, if it's the same price? The theory wasn't stupid. The theory was that rival media manufacturers could pay PC makers to take the untied version. So in practice, that version of Windows would be cheaper. But the practice was that it didn't work. And so we learned from that. And in the next tying case that we did on Internet Explorer, we had, as you say, this choice screen remedy where the consumer chose a browser from a choice screen. And we found that to be very successful. We had over the 5 years of the commitments, those were legally binding commitments. It wasn't an infringement decision. There were hundreds of millions of downloads in Europe of rival browsers. And indeed, you can see that, as I say, thread through to the most recent case on tying, which is Android, where in addition to the usual untying order, there is, and again, this goes to the general theme of effectiveness of the remedy, there is this choice screen remedy, which is being rolled out now, where on startup of the device, the consumer will be able to choose between different search providers, which one they want to be the primary or the default search provider. And that's something that, as I say, we've seen has worked in the past, has the potential to work in the future, and obviously we'll look at it closely. But the theme is learning from the past, adapting and refining to make enforcement as effective as possible.
So I'm just going to close here with kind of a quick hit question, one that's different one for each of you. If you can try to keep your answers at under a minute. Let me just start with Maureen. This is what I call the 51st dates problem, reference to the movie of Antitrust, where you tend to look at every case in isolation and anew, which has clearly some benefits. But we've also seen in a couple of these big breakup cases, the component parts just go back and recombine. Is this a flaw in antitrust approach?
Well, I mean, I think the important thing to remember is that markets are really dynamic, right? And so, so talk about AT&T, right? Breakup there. One of the things they spun off that they didn't, my understanding is they didn't think were very valuable, were the wireless licenses, right? And so now when you think about all the competition that is coming from an area that wasn't even really foreseen. So I just think, again, you kind of need to see each case is different. The remedies may help in, some capacity, as Bill pointed out, but there may be, totally unforeseen kinds of new types of competition that come into the market. And I think we need to be aware of that, right? And not just count on it, oh, like something will ride to the rescue and fix it, but that these things are not static. And companies that looked unassailable at one point have fallen off from that pinnacle because it's difficult. Like, you know, the Yogi Berra, it's hard to make predictions, especially about the future, right? So I think that counts as just a little bit of, that doesn't mean be paralyzed, don't take action when you see a problem in the market, but have, you know, some realization about the difficulty of predicting where markets will go, what the changes will be, what will be successful. So, you know, we all need to approach that with, I think, a little bit of humility that we can design the perfect market and we'll stay that way forever.
So, Bill, question for you. One of Microsoft's defenses at the time was that consumers benefited from having a zero-price browser, because Netscape was charging for its browser at the time. This argument that consumer welfare was enhanced by offering a zero-price product was rejected then. Why are these arguments gaining traction now?
I mean, generally, I think we've suffered from a badly cramped and distorted debate about what consumer welfare means. You can't have the conversation unless you define the concept. I think a standard critique of competition law, certainly in the US, maybe in some extent in Europe, is that when you look at consumer focus, you're not paying any attention to anything other than price, and that dynamic factors, innovation, other effects, effects on labor markets are irrelevant. I think that's a distortion of what competition law has done. As I look through certainly the modern history of enforcement in many countries, it's rare that there's no element of innovation or quality, at least in the case. So if I were to say, is it a perfect defense to say I offer a zero price product or service, and because I offer a zero price product, I'm immune because users like zero price products, and that's the only thing you look at? I'd say, of course not. You look at the effect on entry and expansion by rivals. So I'd say a faithful examination of what consumer welfare means in this larger sense takes into account broader considerations.
Great. And Nick, let me ask you the final question here. I think in Europe for the past couple of years, you know, maybe 7 years ago, they started looking at privacy as a concern. In the last couple of years, there's been more of a focus on digital markets, data markets. What do you see going forward? What do you think the next big issue, the next big concern is going to be?
It's a $64,000 or is it $1 million question? I don't know. Again, I mean, the usual get out is, well, we have to look at everything case by case, which of course we do. I mean, if I go into some of the themes that maybe are more prevalent, I mean, some of the data stuff is interesting in the sense, I mean, you know, we've got this ongoing Amazon case where we opened proceedings last year. I don't know if that's a new thing as such. I'm not sure. Again, conceptually, the framework of analysis is new, but there we're looking at whether the data advantage there's a data advantage that Amazon retail has compared to rivals to compete on Amazon Marketplace. It's an example, perhaps, of the issue that, given the greater importance of data, might be more prevalent in platform markets in the future. And I think linked to that is artificial intelligence. But again, I mean, that's a bit of not a buzzword. It's an important concept. You really need to dig down into the specifics to see the specifics of what's at stake. But I think those kinds of issues are a couple of examples.
Great. So in conclusion, I would like to thank all of our panelists, DG Comp's Nick Manasevic, the Honorable Maureen Olhausen, and the peerless Bill Kovacic. Special thanks to my Vice Chair, Alexander Lifshitz, who came up with the idea for this panel and has been instrumental in pulling it together. Thank you all for this great discussion. And back to you, John.
All right, thanks, Anant. Greg, let's start with you. What were some of your takeaways today?
So one takeaway, and like the old song goes, breaking up is hard to do. As a threshold matter, if the breakup is going to be ordered by a court, the enforcer, of course, must first prove that the defendant violated the antitrust laws. Not necessarily an easy feat under either a Clayton Act Section 7 or Sherman Act Section 2 theory. And even if liability is established, or if instead the breakup is directed by Congress, dismantling a large tech company with many different and complex lines of business would be challenging, to say the least. And so some of the things I'm thinking about here, where should the new corporate lines be drawn? Will the divested business be viable on its own? Will the breakup actually restore lost competition? For better or for worse, there's relatively little precedent and therefore guidance for courts and policymakers looking to break up big tech companies.
Alexander, what are your thoughts?
I think that there are two big takeaways. The first one is that the antitrust agencies do have the tools necessary to break up large corporations, including tech companies. And that is not surprising. We've seen big companies, the dominant companies, been broken up before. It's unusual, but it has been done. But second, and I think this is more important, is that breaking up big companies should be a solution of last resort. And the panelists all seem to agree that the remedy for anti-competitive conduct should be proportional to the anti-competitive harm, and that structural remedies in monopolization cases should only be used if no other remedies, including behavioral remedies, could address the competitive issues. I think this is a very important point that seems to have been lost in public calls to break up big tech companies.
Greg, any other thoughts from you?
Sure. Another takeaway that I have here is that the cure should not be worse than the disease. And I realize that saying has taken on some political baggage during this pandemic, but it really is relevant to any contemplated breakup of the big tech companies. And it comes down to whether overall consumers are going to be better off with the relatively drastic remedy of a breakup. So some of the things to take into account here when thinking about this, are there actually dyssynergies involved in breaking up the company that may outweigh any competitive benefits from the remedy? Will you just end up with a duopoly instead of a monopoly and potentially a very limited amount of additional competition? What will be the long-term effects on innovation, not just in the markets directly at issue, but adjacent ones as well? So these are the types of things that I think enforcers and policymakers need to consider as they think about taking this relatively drastic step of breaking up big tech companies.
Alexander, what about you? Any more thoughts? Any other ideas, takeaways, thoughts?
Well, one more thought, and that is that this shouldn't be looked at like mergers. In mergers, structural remedies are favored, but that is because we know what the market used to look like, and the structural remedies are intended to recreate the lost competition. Here, that's not the case. With big tech companies that have been operating in their markets for a long time, we do not know what the market would look like if they're broken up. We may not know for decades what the implications are going to be. And that should be a significant consideration when, as Greg mentioned, before taking this drastic step.
So watch this space. I think, I think we're going to have an election, I hope, coming up in the fall, and that will help to shake out some of the policy. But it seems like this is an idea that has traction on both sides of the aisle, and be very important to watch how this all develops. As we heard today, a lot of issues yet to be decided. Greg, I want to come back to you and ask you, change gears a little bit and ask you a little bit about the Media and Technology Committee. what has the committee been up to? How can people get involved?
Sure. Thanks, John. I appreciate that. So we have two things going on right now at Media and Technology that touch on the issues that were addressed in the program we just watched. One, along with the Consumer Protection Committee, we are maintaining a global tech enforcement tracker. Available on the Antitrust section's website, it's a first-of-a-kind database that tracks on a worldwide basis all of the antitrust and consumer protection investigations and enforcement actions involving tech companies. We started this tracking tool last August at Brian Henry's suggestion so that folks can see in one place all of the regulatory scrutiny being applied to the tech sector. Second, the M&T Committee has been hosting a series of programs titled Tech in the Global Enforcement Spotlight, which provides a deeper dive into the major investigations and enforcement actions involving tech companies. We held a program on EU developments last January, one on Asia last month, and are in the process of developing programs on US and rest of world developments. So stay tuned for those in the next few months. And as far as getting involved in the committee, we are always looking for volunteers to help us develop committee programming and to draft articles for our semi-annual Icarus newsletter. If anyone is interested, please reach out to me or to my co-chair, Ankur Kapoor.
All right, Greg, thank you. Alexander, just to you as well, tell us a little bit about the Legislation Committee, what you all are up to, how people can get involved.
Of course. The Legislation Committee tracks and provides reports to our members on state and federal legislative developments in antitrust and consumer protection. And right now, one of our big focuses is monitoring the developments in legislation at the federal level of big tech and what's going on. There are definitely several ways that young lawyers could get involved. One is that, just like Greg mentioned, we have an annual and semi-annual newsletter that young lawyers could contribute articles to. We also manage a state legislation monitoring project where young lawyers track states' antitrust and consumer protection developments and post some on the website. And we encourage both law school students and young lawyers to volunteer to participate in this project. And finally, we invite young lawyers to participate in our informal brown bag presentations on legislative developments. These programs enable young lawyers to develop their presentation skills in a more informal and low-stress setting while getting our members useful current information. So if you would like to contribute, please reach out to me.
Alexander, Greg, thanks. You know, this area of big tech. When we put out podcasts that cover the topic, they always seem to be the most popular podcasts that we have. So great panel today. Continue to watch this space. I think the section is really on top of monitoring these developments. So I want to say thanks to Greg and to Alexander. Thanks for coming in. Thanks for giving us this context. Thanks for helping us to understand some pretty complex questions today. I want to also thank Anant Raut and the panelists. A lot of hard work went into that, and I think it came through. Really, really helpful stuff. Most importantly, I want to thank you folks watching us, our members. We really appreciate your joining us for virtual spring meeting. We know it's a little different, but we really thank you for trying it out. And until we speak again, please be safe, be well.